name is Tammie Johnson, and I'm a paralegal and victim advocate at West Tennessee Legal Services. October is Domestic Violence Awareness Month, so we at West Tennessee Legal Services wanted to provide some information to our community members on recognizing domestic violence and the resources that are out there to help survivors of domestic violence. Experience in domestic violence can be frightening and overwhelming. Trying to figure out your legal options may seem like an additional hurdle. Victims will have a lot of questions regarding domestic violence and what can be done to help them. I'm going to try and answer some of those today. Some frequently asked questions are, what is domestic violence and how does someone know if they've been a victim? Well, domestic violence can take many forms. Many people only think of physical violence. However, domestic violence can take many other forms such as verbal abuse, threats, coercion, intimidation, isolation, financial control, and more. If you are in immediate danger or wondering where to start, there are free and confidential resources available. Some are even available to you 24 hours a day. If you want to speak to a local organization, you can contact RAP through their website or their number on the screen. There is also the National Domestic Violence Hotline. You can reach them using the information on the screen. We will also include a list of these resources at the end of the video. Victims will often ask how they can protect themselves or their children from a domestic abuser. Is there a way to use the legal system to prevent the abuser from contacting them? The answer is yes. You can ask a court for what is called an order of protection. An order of protection is a legal order signed by a judge which orders the abuser not to harass or threaten you, and maybe not even to contact you. In Tennessee, you can file for and request an order of protection against any of the following people: your spouse, someone you live with or used to live with, someone you've had a child with, you have or had a romantic relationship with, a family member, or someone you're related to by marriage, like a step-parent. You can also request an order of protection for a child of any of the relationships I just described. You also may ask if you need a lawyer to file an order of protection. You do not have to have a lawyer to file the paperwork requesting the order of protection. However, if you have time, it would be good to talk with a lawyer about helping you with the wording on the paperwork you will file with the court. Lawyers know what Tennessee law requires you to provide proof to qualify for an order of protection, and talking with a lawyer beforehand can help you understand how you can best describe the abuse on the paperwork. Another question may be, what information will they ask for on the order of protection request form? In order to ask for an order of protection, you will need to tell on the paperwork, which is called a petition, how you were harmed. For example, you could say on the petition whether you or your children or pets were physically injured or threatened with physical injury, and how, whether you were the victim of sexual assault or attempted sexual assault, whether you were stalked and how, and whether your personal property was damaged and how. In Tennessee, pets are personal property. Victims often want to know what kind of protections they can ask for in an order of protection. And can they ask that the abuser not be able to contact them or their children? Yes, there are several things you can ask for in your petition for an order of protection. These include stopping the abuser from contacting you or your children, ordering the abuser to stay away from your home or workplace, or ordering the abuser not to threaten you or damage your property. You can also ask that the abuser have to move out of your home if you live together, or if you are married, that the abuser have to provide you housing. You can ask for spousal support, for custody of your children, and child support if the abuser is their father, for custody of your pet, and that the abuser be required to get counseling or substance abuse help. There are other things that you can ask the court to do also. A lawyer can help you understand your options before you fill out the paperwork. Once you get the paperwork filled out, you will officially file your petition at the court clerk's office. It does not cost you anything to file it. The judge will read your petition and how you describe the abuse. Some judges want to talk with you personally at the same time they read your petition, and some don't. The judge will decide whether or not to issue a temporary order and what that temporary order will say. Generally, a temporary order will at least order the abuser not to harm or threaten to harm you or your children. Often, it will go ahead and even order no contact and order the abuser to leave your shared home. The court will set a date for a court hearing, usually within 2 or 3 weeks. The abuser will have to be served, and that's usually by the local sheriff's department, with a copy of the petition and any temporary order signed by the judge, including the upcoming court date. The abuser has a legal right to know what you are accusing them of and what you are asking to happen, and has a legal right to go to the hearing and tell their side of the story. Now, these kind of hearings can be intimidating for survivors. That's why paralegals like me at West Tennessee Legal Services provide court accompaniment for survivors of domestic violence. This means that we will attend the hearing with the victim so they're not there alone. At the hearing, the judge will decide whether or not to grant you the order of protection for up to 1 year, and what specific orders to include in it or not. If the abuser shows up at the hearing and disagrees with what you're asking for, then there will have to be a trial. You will get to testify and tell the judge your side of the story about what happened and what you want. The abuser will get to testify and tell the judge their side of the story. The judge will listen to what each of you says and make a decision about whether or not to grant you the order of protection, and if so, for how long and what it will include. If the judge grants you an order of protection, you and the abuser will both get a copy of the official order signed by the judge. The order will tell the rules that the abuser has to follow. The information about the order is put into a computerized 911 system. Be sure to keep a paper copy of this order with you at all times. In case the abuser violates the order, you need to show the order to the police. An order of protection issued by the court is enforceable by law enforcement anywhere in the United States. You can go back to court to ask for an extension before the order expires if there is a good reason to extend it longer. If the abuser does not follow the rules set out by the order of protection, you should contact the police or the sheriff's department, who can enforce the order. The abuser may be arrested. If someone has an order of protection against them, they cannot legally own or even borrow a gun while the order is in effect. If you have reason to believe that they still have a gun or using one, you can contact law enforcement about that too. If you have any additional questions, contact the resources on the next screen for assistance, or contact West Tennessee Legal Services for legal questions. Thank you.